Chalo, let's start with the next part, which talks about removal of name of the companies. 4 parts out of 6 is already done. First one was talking about the government companies. Second one was your punishment. Third one was dormant company. Okay, then we did registered valuer. In that, most important thing was section number 247. And now we are doing the fifth part, that is removal of name of companies from the register of companies. Okay, this is going to range from section number 248 to section number 252. Basically, 5 sections are going to be there here. Achha, before this, we did government company, right? So government company, we did the definition in 2 clause 45. We did section number 394 and we did section number 395, right? Then we went on to punishment. In punishment, we did 2 sections. That is section number, which section numbers did we do? 447 and section number 450. Right, then we did dormant company. Dormant company, only one section number was there. That was section number 455. Then we went to registered valuers. In that, only one section was there. That was section number 247. Right, and now the fifth part, which talks about removal of name of the companies, which is going to range from section number 248 to section number 252, right? Chalo. So now let's start with this part. This is very, very simple, but at the same time, all the sections, okay, 248 to 252, all the sections are going to be super duper important. Simple hai, but it is important. Okay. Now let's start with section number 248 first. See the heading of this part. Heading of the part is talking about removal of name of companies from register of companies. Okay, now we had seen this in dormant company, that either you will be placed in the register of active companies or you will be placed in the register of dormant companies. We had seen something like that, right? But now they are talking about removal from the register totally, means your name will be striked off. Okay, it is talking about the case where your names can be striked off. Okay, one thing which I would like to tell you now itself, okay, before it creates any confusion, let me tell you this now itself. There can be, like, here we are going to study the circumstances in which the name of the company can be striked off. These are just some circumstances in which the name can be striked off. Apart from this, also in other chapters, you might study the cases where the name can be striked off. So these are not, say for example, here we will study 4 circumstances. Okay, here we will study 4 circumstances in which the name can be striked off. Now, it's not that there are only 4 circumstances where the name can be striked off. Okay, there can be many other circumstances where the name can be striked off. Okay, 248 states only about 4 cases. Okay, now let's try to understand what are the 4 cases where ROC has got a right. Okay, where ROC has got a right that it can strike off your name from the register of the companies. ROC has got that power. See, whenever you register yourself as a company, ROC only puts your name in the register of active companies. Right, so if any of these 4 circumstances gets attracted, then ROC only has that power to remove your name. Okay, to remove your name or to strike off your name from the register of company. Very clear with this? Yes. So now there are 4 circumstances. Just try to understand here what are those 4 circumstances. First of all, if company has failed to commence business. Okay, it has failed to commence business within 1 year of its incorporation. Means it was incorporated, it was formed, but after that it did not do any business. Okay, it never ever did any business for a period of 1 year from the date of incorporation. So in that case, ROC, obviously it will first give you a reasonable opportunity of being heard. It will ask you whether you want to put the name in the dormant company list or whether you want to strike off the name. Right? Accordingly, ROC will strike off the name from the register of the companies. Okay, this is one thing. Or say for example, if the company is not carrying on any business operations in the last 2 years, okay, it is not carrying on any business operations for the last 2 years, and it has not even applied. See, if you remember in the definition of inactive company we had studied, if it is not doing any business operations for the last 2 years, etc., then ideally it should apply for the status of a dormant company. So there is no business operation for the last 2 years, and it has not even applied for the status of a dormant company. Then in that case, ROC will send a notice to the company to reply within a period of 30 days that what are they actually intending to do. Whether do they want to continue or they want to get their name striked off from the register. There's a difference between these 2 points. There's a difference between this first point and the second point. In the first point, you never ever commence the business. Okay, in the second point, maybe you would have commenced the business, but now for the last 2 years, you have been totally inactive. Right? Then the third circumstance. What does the third circumstance talk about? Whoever were the subscribers to the MOA. You understand the term subscribers to the MOA? The people who subscribed to the initial share capital of the company. They subscribed, they signed the MOA, etc., but they did not pay the subscription money. They did not pay for the share capital for the shares that they got. Okay, and declaration for this was not filed by the company. That was not being filed within 180 days of incorporation. Generally, the subscription money should be paid. The subscription money should be paid at the time of subscribing to the shares, means at the time of incorporation. If they do not pay, then the company is supposed to go and file a declaration with the ROC that the subscribers have not paid the subscription money. So, if they have not paid and no declaration is filed. Okay, no declaration has been filed within 180 days. No declaration has been filed within 180 days of incorporation. So in that case, this also becomes one of the reasons where the ROC can strike off your name, right? Or the last one that is totally different, where ROC conducted some physical examination in the premises of the company. Okay, it came and it conducted certain physical inquiry in the place of business, and it came to know that the company is not carrying on. Okay, it is not carrying on business or operations as revealed. Means what I had told to the ROC and what is actually happening, that is totally different. If any one of these circumstances arise, then in that case, ROC has got the power that it can strike off your name from the register of the company. Okay. Again, I am telling you, these are not the only 4 cases where the name can be striked off. If you remain dormant for a period of 5 years, then also your name can be striked off, na? That we had studied in section number 455. So this way, there can be certain more pointers. Okay, but 248 specifies only about these 4 points. Yes? Very clear with this? Yes. So, in these cases, we just saw that ROC has got a power. Okay, ROC has got a power to strike off. Okay, ROC has got a power to strike off. Okay, now, in spite of the powers that is there with the ROC, even the company can suo moto go and make an application to the ROC that, sir, any of these circumstances exist. Sir, any of these circumstances exist. So company, what it can do is, it can pay off its liabilities. Okay, if the company wants to suo moto go and make an application to the ROC, company will have to first pay off its liabilities, and after that, company can pass a special resolution, or it can take the consent of 3/4 of its members, and then it can make an application. See, when we were going for making an application for dormant company also, we had to pass special resolution. Similarly, when you're going for striking of your name, at that time also, you have to pass a special resolution. Means the company will have to pass a special resolution of its members, and then it can go and make an application to the ROC that, sir, any of these 4 circumstances exist, and we would request you to strike off our name from the register of the companies. So either the ROC can remove, or if any of these pointers exist, then even you can go and make an application. Okay, even you can go and make an application after passing SR that please remove our name. Okay, and once that happens, then ROC will cause a public notice to be issued. ROC will give a public notice that, see, we have received so and so application from this XYZ company. Okay, even public should know that this particular company has made an application for striking off the name from the register of companies, because some people might be aggrieved, right? Some people might be aggrieved. Some people would not be even having the knowledge that such a thing has happened. And suppose if you are such a company who is regulated by any other statutory body also, example, if you are a bank, then Banking Regulation Act will also apply, means the control of RBI would be there. If you are a listed company, then control of SEBI would be there, then you'll have to take their approval also. Like company, when it goes to the ROC, before that it has to take the approval from other statutory authorities also. Very clear with this? But a Section 8 company cannot go suo moto. This is the restriction put on Section 8 company. ROC can strike off the name of a Section 8 company, but a Section 8 company cannot go suo moto to the ROC to strike off its name. Okay, what was the purpose? The purpose was to engage itself into non-profit activities. So why do you want to get the name striked off? Okay, our purpose was to do such activities which does not involve any profit, then why do you want to strike it off? Right? So this is not applicable. Suo moto thing is not applicable to Section 8 companies. Very clear with this? Acha, now listen, just try to understand. The notice which was, given, like ROC also gave a public notice, etc. That notice will be published in the prescribed manner in official gazette, etc. so that every general public has got access to it. Right? The notice under both the sections. Notice under section 248(1) and notice under section 248(2). 248(1) means, remember, in the in the second point, we had given a notice to the company to submit representations within 30 days that why didn't you apply for the status of a dormant company? And in 248(2), when company went for a suo moto application to the ROC gave a public notice. So these notices should be published in the official gazette for public information. Okay, and once the time period of giving that reasonable opportunity of being heard, etc., that expires, and we are not receiving any reply from the company, then in that case, ROC will strike off the name of the company. Okay, and it will put a public notice for that also, that so and so company's name has been striked off, and as soon as it is published in the official gazette, after that the company will be dissolved. Okay, first what will happen is, first strike off will happen, then it will be published in the official gazette. Okay, and once it is published in the official gazette, then after that the company is going to be what? The company is going to be dissolved. Very, very clear with this? The company is going to be dissolved. Okay, another thing, but one thing that ROC will take into account is, that company's liabilities have been exhausted. Means it should not happen that ultimately the creditors of the company will suffer. That should not happen. Right? So if you do not want the creditors of the company, to suffer, then in that case, ROC will first make sure that all the liabilities of the company have been paid, or at least the company has sufficient arrangements that the liabilities of the company will be paid off, and we will take a declaration from the management of the company that if there are any unpaid liabilities which you have not shown, or undisclosed liabilities, then you all will be liable. Okay, basically we are trying our level best that the creditors of the company should not be affected. Okay, and they say in section 248 that liability of the person in charge will remain as it is, as if the company is not dissolved. Okay, liability of the directors, liability of the managers, etc. That will remain as it is. Okay, that will remain as it is. As if the company is not dissolved. Very clear with this? Yes. And then the tribunal, once dissolution is completed, once the liabilities etc. are paid, then after that the tribunal, till now ROC was working, now the tribunal will, NCLT will step up into the picture and it will wind up the company, means it will ultimately close the company. Are you clear till here what happened in this particular section? Yes. Okay, so you're basically in section number 248, after those any of those four circumstances have been met, ROC can strike off your name, or you can suo motu go and make an application for striking off the name of the company. Yes, I hope you're clear with section number 248, and 248 is super duper important, especially these four circumstances which we studied. What were the four circumstances in which the company's name can be removed or company's name can be striked off? If the company fails to commence the business within 1 year of incorporation, or if it was inactive for the last 2 years, and it did not even apply for the status of dormant company, so ROC will ask the company to submit representations within a period of 30 days. Then after that, if the subscribers did not pay the subscription money and no declaration was submitted to the ROC within 30 days, within 180 days. And last one, if the company is engaged into any other activity, as we came to know, as it got revealed after physical verification was done. So we just studied about these four circumstances under section number 248. Okay, section number also important, as well as content is also important. Right? Then after that, moving on to the next section, that is section number 249. Okay, 249 is basically an exception to section number 248. Okay, it is an exception to section number 248. Now, what is this particular section telling? They are telling that, in 248, ROC can suo motu also strike off our name, and even we were allowed to go and make an application to the ROC for striking off the name. Okay, so this is an exception basically to section 248 subsection 2. Okay, it is an exception to 248 subsection 2. What did 248.2 say? What did 248.2 say? 248.2 basically said that after passing SR, we can also go and make an application to the ROC for striking off. Okay, but in section number 249, we have got 5 circumstances. Okay, we have got 5 circumstances where we cannot go and make an application to the ROC. Okay, where we cannot go and make an application to the ROC for striking off the name. Okay. Now, why we cannot go, even after passing SR etc., why can't we go and make an application to the ROC? So, just understand one thing, it is not a permanent restriction, but this is just a temporary restriction. Temporary restriction on happening of certain event. Okay, temporary restriction on happening of certain event, that you cannot go and make an application to the ROC for striking off the name. Ma'am, elaborate. What is this? So just see, everyone here. Restriction on making application under section 248 subsection 2 actually, in certain situation. Okay, I have already written here, it is an important answer, so this makes it even more important. Now, an application under section 248 cannot be made by a company. That's why I am telling you 248.2. If at any time during the previous 3 months, 5 circumstances has arisen. Okay, today if I want to go and make an application. Okay, today if I want to go and make an application to the ROC that please strike off my name. But if any of these things have happened in the last 3 months, then today I cannot go and make an application. Okay. Example, if company has changed its name, then wait for 3 months, then only you can go. Means if change of name has happened in the last 3 months, then now you cannot go and make an application. Once that 3 months get over, then you can go and make an application. Okay, or if the company has shifted its registered office from one state to another, then whenever the change has happened, after that, wait for a period of 3 months, then only you can go and make an application. Okay, so first event, what is the first event? First event, if there is any change in name. Okay, any of these circumstances should have happened in the last 3 months. Okay, in last 3 months. So change in name or shift of registered office address from one state to another. Only this, huh? If this has happened in the last 3 months, then wait for some time, then only go and make an application for striking off. Okay, another one. If the company has disposed of majority of its properties or rights, but in ordinary course of business. Okay, but in ordinary course of business, it generally, whenever a company sells off maximum of its property rights, etc., then there is a doubt of going concern that whether the company will continue in the near future or not. But can I say, many a times it so happens that if the company wants to revamp itself, if the company wants to reconstruct itself, then also it sells off the property or rights in ordinary course. So they are telling that if at all you have done this major transaction, then wait for 3 months, then go and make an application for strike off. It's not that you cannot go and make an application, but just wait for a period of 3 months. Okay. Acha. Suppose if you have now been engaged into any new activity, means your object clause has totally changed. Object clause is very, very important. That is nothing but the main business activity of the company. So if you are not engaged in the existing activities and if you want to change it, so the moment you have changed it, after that, wait for a period of 3 months, then only you can go and make an application. Okay. Or if you have made an application to the tribunal, that is through the NCLT, for any compromise or arrangement. Okay, this is nothing but internal or external reconstruction. You must have heard about these terms. Internal reconstruction, external reconstruction means your merger, amalgamation, etc. Right? So if suppose you have already gone and made an application to the tribunal for internal or external reconstruction, let that matter get over, wait for a period of 3 months, then only you can go and make an application for striking off. Okay. See, what is happening here is, what they are trying to hint here is, whenever any major change is happening in the company, then let it get completed, give some time to the public, then only make an application for striking off. Okay, or your winding up is happening. Okay, or your winding up is already happening under Companies Act 2013 or under IBC 2016, then wait. Okay, wait for a period of 3 months. Let's see what is the conclusion of those authorities. Then only go and make an application under section 248 subsection 2. So these are 5 major changes. Okay, these are 5 major changes happening in the company. Okay, these are 5 major changes happening in the company where the ROC is telling you wait for a period of 3 months whenever these circumstances have arisen, and then only make an application for striking of the name by passing a special resolution. Okay. Acha, even after knowing that 3 months have not elapsed, if you still make an application, then can I say there is a contravention? Yes, can I say there is a contravention of section 249? If there is a contravention, then company will be liable for a fine up to rupees 1 lakh and company will have to withdraw that application because it will have to wait for a period of 3 months. But additionally, withdrawing the application is one thing. Plus, it will also be liable for any amount of fine up to rupees 1 lakh. Very, very clear with this, everyone. I hope you are very, very clear with this. Yes. So this was all about your section number 249, which was an exception to section number 248 2, where the company cannot go and make an application to the ROC for suo moto striking of the name for a period of 3 months, for a period of 3 months. इतना समझ में आ रहा है everyone? Are you understanding this much? Yes, are you understanding this much? Okay, this was with section number. This was your section number 249. Yes, this was your section number 249. Yes, let's move ahead now. Let's move ahead to section number 250. Okay, let's move ahead to section number 250. Okay, now assuming you had made an application properly under section 248, or the ROC suo moto striked off your name under section 248, then whatever date is written in the notice of ROC, okay, whatever date is written in the notice of ROC, from that day the company will cease to operate, means it will stop. There will be no business operations now. Okay, whatever was your certificate of incorporation, okay, whatever was your certificate of incorporation, that will be deemed to be cancelled. Okay, that will be deemed to be cancelled. Certificate of incorporation would have been given to you in the beginning, so that will be deemed to be cancelled, right? But very important thing, to protect the interest of the creditors, if there is any liability which is still pending, for that we will assume that the company is in existence. Okay, for that what will we treat? We will treat that the company is still into existence. Very clear with this, everyone? Yes. So this is basically the after effect of section number 248. Okay, section 250 talks about the after effect of section number 248. In 248, the name was striked. So what will happen? The company's operations will stop and the company's certificate of incorporation will be deemed to have been cancelled. But the interest of creditors, okay, the interest of all the liability holders will be protected. Right? This is told in section number 250. Okay, this is told in section number 250. Very clear with this? Yes. And now, going on to the next one, that is section number 251. Okay, 251 talks about what? 251 talks about fraudulent removal of name. Okay, now, say for example, was the company allowed to make an application? Was company allowed to make an application for striking off? Yes, under section 248 we had already seen. Company was allowed to pass a special resolution and it can make an application to the ROC. Achha, what if company made an application because it wanted to deceive the creditors, or if it wanted to evade the liabilities, run away from the liabilities, or to defraud any other person, means the intention of the company was not good. Okay, it was not in good faith. Then the person in charge who is there in the management of the company, those people, not only one, everyone who is there in the management who took this particular decision, that person will be liable for fraud. Now you know this. That person will be liable for fraud, will be punishable for fraud under section 447. Okay, this is one thing. Plus, even that person can be prosecuted. ROC can initiate any other prosecution also against that particular person. If we come to know that the application was done fraudulently just because we wanted to run away from the liabilities, so we made an application, sir, please strike off the name. Okay, if this was the intention, then the person in charge of the management of the company will not be spared. Okay, they will not be spared and they will be liable for punishment under section 447. Very clear with this? Okay, this is given under section 251. Okay, this is given under section 251. Okay, similarly, this was one particular part. Okay, this was one particular part. Yes, So now let's move ahead. Okay, so now let's move ahead to the next section, that is section number 252. Okay, let's move ahead to the next section, that is section number 252, which talks about appeal to the tribunal. Okay, which talks about appeal to the tribunal. Last section of this particular part. Okay, now listen. Can I say striking of order? Striking of order was passed by whom? Who had the powers? ROC had got the powers. So ROC would have passed an order. Okay, now say for example, if ROC has passed an order and if any person is aggrieved. Okay, if any particular person is aggrieved, that person can go and file an appeal to the NCLT, that is to the tribunal, within 3 years from the date of the order. Any particular person who is aggrieved can go and file an appeal to the NCLT within 3 years. Okay, and now, can I say now the matter has come in the hands of the tribunal? Tribunal will see the case, and if tribunal is of the opinion that striking off was done, but it was not justified. The striking off that was done is not justified. Is not justified means what? Is not justified means those circumstances were not at all there for striking off the name. Remember, we studied 4 circumstances for striking off the name. But tribunal comes to know that those circumstances are not at all there. Then in that case, okay, I'm writing here, no circumstances were there. Then in that case, tribunal can say that please restore back the position. Tribunal will tell to whom? Tribunal will tell to the ROC that please restore the name. But yes, obviously everyone will be given ROBH. Before tribunal takes any decision, everyone will be given ROBH. So if baselessly the name was striked off, then go and file an appeal to the tribunal within 3 years and then the tribunal will take the final decision. If this is not further appealable. Okay, 248 order is not further appealable. Okay, acha. Now listen, there was also a note which was inserted in this particular section. Just try to understand. Okay, I'll just show it to you from the textbook. In section number 252, this was about the appeal point. Okay, now if ROC is satisfied that name of the company is struck off from the register, ROC is satisfied that name was struck off either inadvertently, means wrongly, or on the basis of incorrect information that we receive from the company. And now ROC itself thinks that restoration should be done. Then within 3 years of the dissolution order, it can make an application to the tribunal that, sir, please let's restore this. Did you understand the difference between the above point and this point? In the above point, any other person was aggrieved by the ROC's order. So other person went and made an appeal to the tribunal that, sir, please restore it. Here, ROC has a self-realization. A self-realization has happened in case of ROC. That maybe ROC has struck off the name wrongly. Then ROC will make an application to the tribunal. ROC will not go and file an appeal. It was its own order. So ROC will simply go and make an application to the tribunal within 3 years that, sir, let's restore back the name. This was my mistake. Okay, this was my mistake. So in this note, there is a mistake that has happened by the ROC, and in the above point, now the tribunal is changing the opinion. So that's why in the above point, it was talking about appeal, and this is kind of rectification of mistake. Very clear with this? And in either of the case, we can go within how much time? In either of the case, we can go within a time period of 3 years. Right? And then see, listen, once the tribunal passes the order, that will be filed with the ROC within 30 days. The name will be restored and a fresh certificate of incorporation will be issued because my old certificate of incorporation was cancelled. So now a new certificate will be issued. Okay, and the company will come into existence. Okay, the company will again come into the existence. This was one thing. Okay, this was one thing. Now going on to the last point. This is also very, very important because we need to understand the difference. Okay, we need to understand the difference, everyone here. In the second point, we had seen that any person, or in the first point itself rather, any person who is aggrieved was allowed to go and file an appeal to the tribunal within 3 years. Now here, company or its members, creditors or workmen, means the insider persons, either the owners of the company or the creditors or workmen of the company, aggrieved by struck off of name from the register, may apply to the tribunal, not appeal. They will go and make an application to the tribunal before 20 years from publication in the official gazette. Remember that striking of notice was published in the official gazette. From that date, within 20 years, these people, if they are aggrieved, they can go and make an application to the tribunal that, sir, please reconsider this. And if the tribunal is satisfied that company was carrying on business, that was in operation, means the company was not closed, the company was working fine at the time of striking off, and sir, let's restore back the name, then tribunal can get the name restored and the company will be put in the same position. The company will be put in the same position. This will happen if these people prove that company was in operation when the name was struck off. So they can go and make an application, not appeal. Okay, they can go and make an application to the tribunal within 20 years that, sir, please restore back the name. So here it's not that ROC's order was wrong. Okay, it's not that we are aggrieved by the ROC's order. No, we are simply requesting to the tribunal, sir, please restore back the name. Okay, so if I want to make a summary here, just try to understand. Just try to understand. First of all, striking of order was passed by whom? Striking of order was passed by the ROC. Okay, now say for example, if any person is aggrieved, by the ROC's order, then that person can go and make an appeal to the tribunal that, sir, on no circumstances, as per no circumstances, the name should not have been striked off. And they can go and file this appeal within a time period of 3 years, and then the tribunal will take the final decision after giving ROH. Okay, another thing. ROC has realized its own mistake. That name should not have been striked off. Then it can go and make an application to the NCLT within 3 years. Okay, it can go and make an application to the NCLT within 3 years that, sir, let's restore back. Okay. And last one was the case where company or its members or creditors or the workmen, okay, these people, they just go and make an application. We can say a request application, not an appeal. Okay, they just go and make a request application to NCLT that, sir, company was in operation. Means when the name was struck off, at that time the company was into operation. So, sir, please restore back. And this can be done within a time period of 20 years. For this, you get 20 years. Within this much time, the name we can go and make an application to the tribunal that, sir, please restore it back. Okay, so see, appeal is only the first one. Next one was ROC has realized its own mistake, and in the last one, we are just going and making a request application. Okay, we're just going and making a request application to the tribunal, and this has the longest time period. This has a time period of 20 years. First two had a time period of 3 years. Very clear with this, everyone? Yes? Okay, so this was all about your section number 252, right? This was all about your section number 252. So this was all about your section number 248. Okay, this was all about your section number 248 to section number 252. Okay, all the sections are super duper important, especially 248 and 249. These two sections, first two sections of this particular part, these two sections are going to be the cream sections which can be directly tested in your exams. Okay, I am not telling that other three sections are not important, but out of five also, the most important sections are section 248 and section number 249. Very clear with this? Yes? Okay.